My name is Matt Capilouto. On December 22nd, 2019, the unimaginable happened to our family when my daughter Alexandra was sold a pill she thought was Percocet. She received a counterfeit pill made with a lethal dose of fentanyl. She died within minutes in her bedroom. Out of this tragedy, we came up with Alexandra's Law, a tool that would help deter drug dealers from selling fentanyl, causing instant death. What you are about to watch is a Senate committee hearing on the fentanyl epidemic. In context, Alexandra's Law is an admonishment, a warning. It's mirrored after DUI law. If you are convicted of a DUI in California, you'll sign a form known as a Watson advisement. It informs you about the dangers of driving under the influence. If you do it again and a death results due to your reckless disregard for human life, you can be charged with second-degree murder. We know it as vehicular homicide. We molded Alexandra's Law directly after the Watson DUI admonishment, but in Alexandra's Law applied it for the use of fentanyl dealing. Selling counterfeit pills made of fentanyl clearly meets the definition of reckless disregard for human life. Senators, in their own words, ignorant of current state law when compared to the proposed legislation, Alexandra's Law, or worse, a dedicated effort to stop any law that will put fentanyl traffickers and dealers in prison. You judge if these senators are clear and accurate or conflating and misleading Californians.
For that legally consequential, serious step to happen, that you should at least have known or should have known that there was fentanyl in what you were selling. Not even requiring only actual knowledge, known or should have known. That is not in this bill. I want to be very, very clear. There's been a lot of comparison to DUI and the Watson admonition. When you are drunk driving, to get convicted of drunk driving, you know that you drank alcohol. You know that you got into a car. It is all with knowledge or intentional. And in fact, I'm not a DUI expert, but my understanding is that if you did not know that you were drinking alcohol, if someone slipped you alcohol and you did not realize it, that is actually a defense to a DUI charge. And so comparing this without that knowledge or should have known requirement, comparing that to the DUI context is not a good comparison.
So Senator Wiener is mistaken. That's not correct. We don't, as a prosecutor, you don't have to prove that someone knew they were impaired at the moment they drove. So you have to prove that they were impaired, that they drove. Those are two elements. Under California law, if someone is 0.08 or more of blood alcohol, then they're over the legal limit, and we can show that, and then we don't have to prove that they were actually impaired or that they had any bad driving or anything like that. And so he's conflating these two things. They do not have to know they're impaired when they drive.
And the idea that some college student selling a pill to his roommate and having no idea and no reason to know that there's fentanyl in there would then get this nuclear murder warning on his or her record, I think that's a step too far.
Are elected officials letting fentanyl dealers get away with murder in our state, in our homes? You decide for yourself.
And I think people should at least have to have had some indication that what they were selling had fentanyl in it for this to apply. So, Madam Chair.
Okay, I want to comment on that. He says that people should have to have some indication for this to apply. They do. Once they get the conviction, that's your indication that you sold fentanyl, right? So the law doesn't say when you sell fentanyl, you absolutely have to know that it's fentanyl. If you're dealing drugs, which is illegal, and we find it was fentanyl, and the dealer says, I didn't know it was fentanyl, I thought it was cocaine. Well, you're still guilty of a crime in California. That doesn't get you off the hook. So all this does is say, well, there was fentanyl in that pill, and here's your warning for any future conduct. And it's basically implicit. It doesn't say, but implicit is, hey, make your choices wisely in the future. You might want to stop dealing drugs.
We now know that you can procure fentanyl-laced drugs on the internet faster than you can order an Uber or a Lyft. So let us say you're a young person who did. You procured 10 Percocets. You believe that it is actually 10 Percocets, and you sell some of those Percocets to another friend. You do not believe that there is fentanyl in them. And you had sold Percocets before, and there was no fentanyl in it.
So what she's leaving out is the person is convicted in a court of law. So they're going to stand before a judge, and they're going to be told you're guilty either by plea or by jury. You're going to be told you're guilty, you were found guilty, this is your punishment. Oh, and by the way, here's your warning that what you did is dangerous to human life. So she's leaving that out because in this example, she's making it sound quite innocent that on 2 occasions, this person didn't know that he was selling fentanyl. And that's just not the case, because in order for the admonition to work on at least one of the occasions prior, he would have gotten the warning that said, you actually sold fentanyl. So, again, it's kind of sleight of hand, and it's used to mislead the public here, making it sound so innocent.
The fact that you could be fearful that if the person's overdosing, that you could be convicted, that would lead you then to not call 911 and intervene in the overdose. These are the types of things we are trying to avoid.
Another way to mislead, if somebody has been admonished prior that they have previously sold fentanyl, and now they're selling fentanyl again, and someone starts overdosing, that person's going to have every incentive to call for help because they don't want this person to die, right? Because if the person doesn't die, there's virtually no punishment in California for dealing fentanyl. So they're going to have every incentive to get this person help and call immediately. So it's the opposite of what she's saying. She's making it seem like someone's going to be fearful of the police and prosecution and therefore not call for help. It's quite the opposite.
But as Senator Wiener pointed out, this is not the same as the Watson advisement in our DUI bill. And I fault myself for not bringing this up in the past hearing. I did bring up the issue of the Watson admonishment, but I did not bring up the way the committee's analysis is written, because the committee's analysis, upon reading it, would give one the impression that the way this advisement is structured is comparable. In fact, the committee's analysis says it mirrors. This bill does not mirror the Watson admonishment.
This bill is much more restrictive than the Watson advisement. To be very, very, very clear, to get the Watson admonishment or advisement, you need not know that you're driving drunk at the time you were driving. You get that advisement. Or convicted of driving under the influence, you get the advisement. The prosecution need not prove not only were you driving beyond the limit, but that the time you got in the car, you knew you were driving beyond the limit. That's simply not the case.
I'm not a lawyer, so my apologies for if I am explaining it in a way that may not be as accurate from a legal perspective. But the point is that there has to be knowledge.
The limit. That's simply not the case.
He's right. That's exactly right. My prosecutors go into court. DUIs is among the most common prosecutions that we have, and never do we have to prove that at the time of driving the person knew they were over the legal limit or that they were impaired. It's simply not a requirement under the law. He's absolutely correct on this.
The case, just like here. And we will make our advisement a mirror image. If there's other issues, the knowledge part is not part of the Watson advisement. We'll make our bill a mirror image. In terms of requiring that the individual on their second time they're convicted, we've already added the language they knew or should have known the second time they're convicted that they were selling fentanyl. We'll add that. I don't recall anybody suggesting that we add fentanyl to the phrase, you are hereby advised that the illicit drugs and counterfeit pills contain fentanyl. But we'll add that. That's fine. That's fine. But the requirement, just like in drunk driving, that you somehow have foreknowledge and the prosecution need prove you have foreknowledge is not part of the advisement. Now, this advisement or admonishment, you get it when you've sold fentanyl. The second time you sell fentanyl and you kill somebody, that's just like in all other crimes. That's part of the enhancement. Now, it doesn't automatically come in.
So he's right again. Just because there's an admonishment doesn't mean that anything's automatic. It doesn't mean that that the judge has to let any of this in. If somebody is a fentanyl dealer and they're committed to that as their lifestyle, and let's say they get 3, 4, and 5 convictions for dealing fentanyl, there's no additional punishment. We could show, look, they've been convicted 4 or 5 times of selling fentanyl. They've gotten admonitions each time, and it has no effect on the committed drug dealer, not the casual. We're not talking about the casual college student who sells one pill. What we're talking about here is a warning that has no additional punishment, no additional jeopardy for the defendant, and it's this idea that it's going to sweep up a broad range of folks is nonsense. I don't know where they're getting that.
We've seen this movie before, in the 80s and the 90s, with mass incarceration, zero tolerance on the war on drugs, and there are thousands of black and brown people doing life in prison for selling an ounce of cocaine where no one lost their lives.
Understanding the DUI law and reckless disregard for human life in mind, listen to California state senators try to disparage Alexandra's law presented by experts and then refute the recommendation of their own counsel.
Okay, thank you, Senator Umberg. Anyway, and I do feel frustrated that our committee analysis reflects that this is a mirroring of the Watson admonishment when it is not. If this mirrored the Watson admonishment, I would be an aye vote. And we have offered to Senator Umberg a number of times language that would mirror the Watson admonishment, and I have committed to him I would vote aye. I cannot vote aye in its current form.
So that's just not what she said is factually incorrect. This is exactly the Watson admonishment mirrors SB 44. SB 44 mirrors the Watson admonishment.
The second time you sell fentanyl and you kill somebody, that's just like in all other crimes. That's part of the enhancement. Now, it doesn't automatically come in. There's still a process. If a prosecution tries to offer your prior knowledge, there's a whole process, as Senator Wiener knows, the Evidence Code 350 process as to whether or not something is prejudicial beyond probativeness. But I don't know how to make it clear, and I'll be happy to make sure that if this bill passes out and you don't believe that somehow we're mirroring the Watson advisement, then by all means bring it back to this committee.
And there's no difference. This idea that you can't compare DUI with the selling of fentanyl is just not true. And Senator Umberg's right. It mirrors it, and he seems like he's basically saying, look, being transparent, if anything changes, we'll bring it back to the committee. I think he shows great confidence in he knows what he's talking about. Even if this law passed, it's not the case where we're going to have huge numbers of people being prosecuted for this. That's not true. These cases are incredibly difficult to put together. It requires a homicide level detective work on basically what are drug related deaths. And so it's really the rare case that will make it all the way to the prosecutor's office for filing.
Less than 1% come out of your county.
Yes, and we're the most aggressive in the state, right? So yes, we're the most aggressive, and still it's less than 1%. When the evidence tends to exist is when you have someone who's really a committed drug dealer. But the casual college student who just hands someone else a pill,
Not going to happen.
we don't look at those kinds of cases as appropriate for second-degree murder.
Framework that the safety committee are putting out there is inaccurate.
It's completely misleading. They're taking a very small segment and they're taking an extreme example and assuming that the prosecutors would sweep in all these young college kids who are handing each other pills. There are real drug dealers out there that are peddling this poison. That's who this will apply to, not to the casual user who hands a pill to his friend.
Alexandra's law has come before this committee 4 times in the past 3 years, and 4 times they have refused to send it forward for a vote by the full Senate. Why? Because they know it would pass. The Senate Public Safety Committee has not passed a single law holding fentanyl dealers accountable, and now California leads the nation in fentanyl deaths.